Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today is developments in copyright law affecting tech transactions. Copyright, of course, is an IP right that is at the heart of many technology deals. It's, after all, a form of intellectual property protection most often used to protect software, and software in one form or another is critical to almost every technology deal. So today we're going to be hearing from two practitioners in the copyright space about recent changes in copyright law and how those changes might affect tech deals. I'm your host, Julian DeBell. I am a senior associate in Mayor Brown's technology and IP transactions practice. I'm joined today by my colleagues Richard Asmus and Oliver Yaros. Rich is a partner in the intellectual property practice in Chicago. Oliver is a partner in the intellectual property and IT group and is based in our London office. Rich, let me ask you first, tell us about recent changes in U.S. law. What should we know about?
Thanks, Julian, and hello, everyone. In the U.S., there have actually been both statutory and case law developments of note, and I want to start with the statutory side. In 2020, Congress passed the Copyright Alternative and Small Claims Enforcement Act, called the CASE Act, which created a small claims court for copyright cases with streamlined proceedings and limited damages. That may not seem that recent from the vantage point of 2022, but in fact, the Copyright Claims Board hasn't even heard its first case and won't until later this spring. The idea behind the CCB, as it's called, was to make it easier for small copyright claimants to bring claims that might be too small to justify the expense of full federal court litigation.
Oh, okay, that's an interesting development. Why does it matter for tech deals?
So clearly the tech deals that we work on aren't going to end up before the Copyright Claims Board. They're too big for that. But if the CCB lives up to its promise, it's going to lower the barrier to entry for unsophisticated copyright owners to bring cases, potentially expanding the scope of copyright enforcement. To the extent your tech deal is going to involve user-generated content, for example, or other uses of media that might generate copyright risk, the advent of the CCB has the potential to make small but potentially annoying claims more likely. It's a good reminder to make sure that risks of this nature are accounted for in your indemnity clauses and that the parties are cognizant of these copyright risks.
Okay. Are there other changes in U.S. copyright law that tech deal lawyers should be aware of?
There have been a number of fascinating decisions in the copyright arena. Last 5 to 10 years have been a real bounty of interesting cases. But probably the most salient one for tech lawyers is the Google versus Oracle decision from the Supreme Court, which involved, among other issues, the copyrightability of an API and whether certain uses of an API constituted fair use. And an API is an application programming interface. It's a way that programmers are allowed to, for example, call programs when they're doing their coding. And fair use is a statutory exception to the exclusive right of a copyright owner. Sometimes it's called a defense, but that's not quite right. A use is considered not an infringement at all if it is considered fair use. And the statute provides 4 factors for fair use, including the purpose of the use, the nature of the work, the amount of the work used, and the effect of on the potential market for the use. The Oracle case has a lengthy history I won't bore you with, but it related to Google's use of certain declaring code that was part of the Java API. Java is a programming environment that makes it easier for programmers to write for multiple platforms, and Google wanted to use Java in connection with its Android phones. After licensing negotiations with Oracle broke down, Google used parts of the existing API to write its own Android operating system, and Oracle sued. The question was whether the API was copyrightable at all, and if it was, whether Google's use was so-called fair use. Many commentators expected the Supreme Court to take up the first question, namely whether an API is copyrightable. But that was apparently a step too far for the court, which instead assumed, for purposes of its analysis, that an API was copyrightable, leaving the copyrightability question for another day. Instead, the court determined that Google's use of the Java API was fair use, noting that the API was bound up with unprotectable ideas, was transformative, that is, that the use was transformative, and that Google used very little of the overall Java code. One thing that may have surprised commentators was the commercial nature of the use was not dispositive, and that's a factor that many had felt previously was a critical part of any fair use analysis.
Okay, so for tech deal lawyers trying to navigate these choppy waters, what are the takeaways?
So there are a few takeaways. First, although the Supreme Court did not reach the question of the copyrightability of an API, the status of APIs as copyrightable is clearly open for debate. In the course of the decision, the Supreme Court definitely threw some cold water on copyrightability of APIs. This could impact the way companies contract for API development and usage. Indeed, in those contracts, the putative copyright owner may not have the backstop of copyright law as an overlay on its contractual rights. Second, if companies want to maintain control of their works, they should make sure licensees are bound to strict rules that prevent fair uses that may have been expanded by the Supreme Court's decision.
All right. What else do tech lawyers need to know about?
So I want to go back to the statutory side of things, not to talk about existing law, but copyright law reform that's on the agenda for 2022. In particular, Congress is considering amendments to the Digital Millennium Copyright Act, the DMCA, and in particular to strengthening the requirements that service providers adopt technical measures to prevent copyright infringement. Senators Leahy and Tillis very recently introduced the Smart Copyright Act of 2022. Other reforms under discussion include amendments to the safe harbor provisions of the DMCA. This is something to watch out for in 2022 if Congress can get the legislation done before the new Congress is sworn in 2023. And indeed, this issue of DMCA reform is likely to be on the agenda in future Congresses as well. The DMCA at this point is nearly 25 years old.
Okay, yeah, well, long overdue. But what's the effect of this reform going to be, as particularly for the safe harbors? Is it going to make them more difficult to meet?
The proposed reform would increase the obligation of service providers hoping to avail themselves of the safe harbor, moving from what we call a notice and takedown system to more of a notice and stay down system. Note, however, this is actually not in the Smart Copyright Act of 2022 that was recently introduced, but reforms along those lines have been considered in previous Congresses, and it's certainly a potential that we'll see that reform in the years to come.
Okay, plenty to keep track of here in the U.S. Thanks, Rich. Over in Europe, let's find out if there have been any major recent developments there. Oliver, what's going on that we should know about?
Thanks, Julian, and hello, everyone. Well, in Europe, there have been a number of cases that clarify the position in terms of ownership of copyright in software. What sort of acts will constitute infringements of that copyright, which is obviously important for any customer that is receiving a license of technology from a supplier in a tech transaction. So the first case I wanted to point out is the one of Top System SA versus Belgium, which is a case in the European Union, and it was heard in October of last year by the Court of Justice of the European Union. This case relates to the scope of one of the exceptions that exists from the exclusive rights of the right holder in a computer program to copy and alter the program. So under European directives relating to software, the licensee or another person having the right to use a copy of software has a right to decompile the software without needing the permission of the owner or licensor of the copyright in the software. Now, the scope of the exception allows the licensee or third party to do this, where the reproduction of any code and the translation of its form would be indispensable to obtain information necessary to achieve interoperability between that software and another program that it might be using. Now, in this case, Top Systems issued proceedings against the Belgian state as a defendant, and this followed the decompilation by the wittily named Selection Office of the Federal Authorities in Belgium, or CELOR, of a computer program that was developed by Top Systems for CELOR, and so CELOR had a license to use it. Top Systems had developed technology for CELOR, but CELOR was experiencing problems with it and said it decompiled the software to work out how to disable a defective function and correct errors within it so that it would work with its other software.
Okay, so why might this case be of interest to customers seeking to deploy software from third parties in Europe?
Well, I think it's interesting because the lack of interoperability of software and problems integrating software you've obtained into your environment is a common cause of disputes between customers and suppliers in tech transactions. Customers are frequently asking what they're able to do to integrate software into their environment without having to go back to suppliers and having to pay them hefty integration fees for their help to make it work. I think the interesting thing about this case is that the CJEU held that a lawful purchaser of a software program was entitled to decompile all or part of it to correct errors in the software it was acquiring that was affecting its function. So that would include the right to disable functions within the software that affect the operation of the program without having to go back to the software owner or the licensee to get consent where the decompilation was necessary for the use of that program by the customer.
Okay, a very interesting development indeed. What other developments then in Europe relating to software should tech deal lawyers be aware of?
Well, one topic that will be familiar to many tech lawyers is the part of any negotiation or dispute where you're examining the liability caps and potential remedies available in a situation where you're trying to assess what types of loss for contravention by the customer might be classed as a breach of contract and so be subject to all the usual caps and exclusions of liability tied to fees that are paid or payable, or what remedies or what actions might be available for infringement of copyright in software, which might be separate from breach of contract claim and might be subject to higher caps or even no cap. Now, there's a case called IT Development SAS and Free Mobile SAS, which is a case coming from France. And in this case, the claimant, who is a service provider, entered into a license agreement, a maintenance agreement with a defendant, which was a French mobile operator. And this agreement was for the use of a software for the organization and monitoring of the deployment of the customer's radio telephone antenna. Now, the claimant, that is the service provider here, alleged that the defendant, the customer, had modified software and that actually this breach of contract in itself constituted copyright infringement. Now, interestingly, a previous Paris Court of Appeal ruling in France provided that a licensee acting in breach of a software license does not necessarily commit copyright infringement, and that actually general contractual liability applies instead for breach of contract. Now, in this particular case, the Court of First Instance followed the ruling and the claimant appealed. And the Paris Court of Appeal then referred this question to the CJEU and asked whether a breach of a software license can constitute copyright infringement or whether you're actually looking at a breach of contract claim as a separate action. Now, the CJEU considered that for EU law on this point to be effective, it must be interpreted as meaning that the breach of a clause in a license agreement for a computer program relating to the IP of the software owner falls within the concept of infringement of IP rights.
Okay, well, what are the implications of this ruling?
Well, what this means is that where a customer breaches a clause in a license agreement that affects the provider's copyright in that software, their rights, their IPR in that software, that will constitute an infringement of the provider's IPR and will be subject to different liability positions and potentially different remedies for the service provider that would typically be afforded for infringement cases versus having to go for a simple claim for breach of contract. So customers should tread carefully when drafting the liability cap and exclusions language relating to IP infringement so that it only covers those acts which really can be said to relate to the customer's use of the software rather than broader breaches of other parts of the contract, which they might typically regard as being a breach of contract issue rather than an infringement issue.
All right, thank you, Oliver. Any final developments we should be aware of?
Sure. One final common theme that customers and suppliers find themselves grappling with a lot is the development of software by key individuals where they claim it has happened outside the scope of their employment and how that might affect the rights a customer may have to use it. So in a UK case, Penhallrick and MD5 Limited, this was a case where the claimant, an individual, claimed to have developed certain parts of the software used and sold by a service provider prior to that person's employment. And he also claimed to have owned elements of the software that he had developed after that employment had finished. Now, in this case, the court determined from an examination of the facts that the claimant had only started work to develop the software after his employment commenced. So that was easily disposed of. But then to think about the elements of work that he did while he was working both as an employee and then later as a consultant, the court had to look at a number of factors to work out who was the owner of the copyright. So to determine whether the defendant, the company, was the first owner of the copyright, the court had to establish whether the works had been made in the course of the individual's employment. And that required a multi-factor assessment, looking at things like the terms of the employment contract, where the work was created, whether the work was created during normal office hours, who provided the materials for the work to be created, and the level of direction that there was to the individual, and whether the individual could have refused to work on the project, and whether the work was integral to the business of the service provider concerned. From looking at the facts of the case, the court determined that all the work that was produced by the claimant was done, in fact, in the course of his employment, even though the court considered the claimant's arguments that some of his work was carried out using software at home, it was done outside of office hours on his own personal laptop. The court still considered that these factors didn't displace the strong and primary indication that it was work done in the course of his employment and so should belong to the service provider who paid him.
Okay, let's hanging from that. What are the lessons we can learn from the case?
So I think it's important for customers and suppliers to be clear with each other about which individuals are key to the development of any software that might be provided to customers, and that the individuals involved are either all employees at the time that they work on the relevant software, or, where this hasn't happened, that they've signed contracts that at least contain robust terms assigning ownership of copyright they might have to the right business early on. Any software which individuals have brought to the table from work they've conducted prior to their employment should be treated particularly carefully, and agreements assigning or licensing the copyright to use this technology to the right party should be put in place following that assessment.
Oh, thank you, Oliver. And thank you, Rich. Thanks to both of you for your insights today. Listeners, if you have any questions about today's episode or an idea for an episode you'd like to hear about anything related to technology and IP transactions and the law, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.